I'll just send a quick email to the others, but we can get started, Jen, and then I'll let them in as they trickle in slowly.
Yeah, sure. So, Justin and Joe, welcome to Marrickville Legal Centre's Lunch and Learn series on underpayments as part of Law Week. I'd just like to acknowledge the traditional custodians of this land, the Gadigal people of the Eora Nation, and pay our respects to elders past, present and emerging. Just a few housekeeping things before we kick off. I think Tu said that this presentation is going to be recorded, so feel free to keep your cameras off if you like, and the recording will be made available after this presentation. The presentation is also not a substitute for legal advice, so if you're experiencing a specific legal problem or need a specific legal question answered, you should seek legal advice either from us or from anyone applicable. I will be presenting or distributing a range of contact details at the end of the presentation in case you need that specific legal advice. Now, my name's Genevieve. I'm an employment lawyer with the Marrickville Legal Centre. Marrickville Legal Centre is a not-for-profit community legal centre based in Sydney's inner west. We provide a range of services to a very large catchment area across New South Wales, but particularly the inner west and southwest New South Wales. We do employment law, civil, family law matters, criminal matters, a range of tenancy and strata advice. So we're a pretty holistic service based for advocating to our disadvantaged communities. A quick snapshot of what we'll be covering today in the session. I'll be looking at the sort of onboarding process and the documents that your employer should be asking you when you first start, so your tax file number and superannuation details. We'll be looking at the national employment standards that sort of underpin all working relationships in Australia. We'll be looking at the types of employment, so whether or not you're employed as a full-time, part-time or casual employee, and the pay and entitlements that flow from that sort of classification of the employment relationship. Now, importantly, we'll look at contracts of employment, modern awards and enterprise agreements, as they will specifically govern the terms and conditions of your employment, specifically your pay and entitlements. Look at the payslips and whether or not your employer can make deductions from your pay. If you look at your payslips and discover you've been underpaid, or you think you've been underpaid, we'll talk about how you would approach your employer or what steps can be taken to recover any sort of underpayment. As I said before, we'll be looking at a range of resources and contact details so that you can follow up any underpayments, and then I can open up the session for any questions you may have. I think the most important sort of overarching theme throughout today is if you sort of equip or arm yourself with the information about what sort of employee you are, then you're going to be much better able to monitor your pay and entitlements and enforce them. So keeping records, keeping pay slips, keeping timesheets, asking questions of your employer, seeking legal advice if you need it, they're the most important sort of elements in pursuing and monitoring your pay and conditions. Okay, so onboarding. At the beginning of your employment, your employer should be asking you for your tax file number. It's a personal reference number for tax and superannuation. If they are not asking these details of you, this should sort of raise a bit of a red flag for you. It may indicate that the employer is not paying you your superannuation correctly or attributing tax correctly. It could also indicate that you may be engaged as an independent contractor. So it's always best to ask questions of your employer at the beginning of your employment when you first start. If you don't have one, you can get one from the ATO provided. Now, the National Employment Standards are a series of 11 minimum terms and conditions that apply to all Australian workers. You should think of it like as a safety net of entitlements. They're the minimum terms and conditions that apply to all Australian workers. You may also have a contract of employment, but the national employment standards will sit underneath and make sure that your terms and conditions don't fall below what's set out in the national employment standards. So depending on whether you're a full-time or a casual or a part-time employee, your minimum terms and pay should not fall below the national employment standards. And they will vary depending on the type of employee that you are. Now, as I said before, you can see in this graph, the national employment standards sit underneath and apply to all employees. You may have a contract that provide for above NES entitlements. You may also have a contract and award that applies to your employment, but the national employment standards will make sure that that safety net is there, and you should always be checking that it doesn't fall below. Looking at the different types of employment, as I discussed before, there's full-time, part-time and casual workers. As a full-time employee, you can see here, these are the range of entitlements that you get. So your weekly working hours are set by the National Employment Standards as a maximum of 38 hours a week. You should not be working more than that, and if you are, you need to be paid for it. If you're a part-time employee, that is an employee working less than 38. So even if you work 37 hours a week, you will be deemed a part-time employee. A casual employee is working irregular hours. So you could be contracted, say 15 hours a week on a roster, and that 15 hours a week is distributed irregularly throughout the week. Or you may be contracted as a casual for 15 hours a week, just working Mondays and Tuesdays, but there's just no set hours attributed to casual employees. In terms of personal leave and annual leave, full-time employees are entitled to accrue these two benefits. Unfortunately, casual employees do not. So for a personal leave entitlement, full-time employees get 10 days a year that accrues throughout the year. A part-time employee would accrue a pro rata entitlement. So what that means is if you're working, say, 75% load of a full-time employee, so let's say 28.5 hours a week, you'll receive 7.5 days personal leave and 3 weeks annual leave each year. Okay, the national minimum wage applied to all employees, if you're 21 years or over, is $20.33 an hour, and that must be the minimum wage that you receive. If you fall below this rate, you are likely being underpaid. Now, casual employees have a higher rate of pay because they don't accrue these leave entitlements. So there's 25% loading per hour on the hours worked for a casual employee. So the minimum national wage for a casual employee must be $25.41. Other entitlements for full-time employees is and part-time employees is that you get notice of termination. So it's if you've been working for 18 months, you should receive 2 weeks notice if you are terminated from your employment. You should also receive a reason for your termination, particularly if you've met your minimum employment period. Casual employees, on the other hand, also don't get notice of termination. Again, the entitlements don't accrue. Instead, casual employees are considered that their employment terminates at the end of every engagement, and the loading is meant to compensate you for the notice of termination. So at the beginning of your employment, determine what sort of employee you are, and then make sure that these benefits and these entitlements are somehow reflected in a written document or a verbal agreement with your employer. That way you can pursue these and track these entitlements across your employment to make sure that you're not being undercut any entitlements. So as I said before, there's a national minimum wage. Every employee is entitled to that national minimum wage. For full and part-time employees, it's $20.33 per hour. The casual employees get the 25% casual loading on top of that. Most employees and most employment arrangements are covered by a specific modern award though. And so this may entitle you to a greater entitlement above the national minimum wage. So here we're looking at the operative documents that will govern the terms and conditions of your employment. We've already discussed that the national employment standards acts as that safety net. And so the minimum national wage is the minimum that you must receive, and the annual leave and personal leave entitlements are those minimums. Now, your contract of employment, your modern award or enterprise agreement may provide greater entitlements above those minimums set out in the national employment standards. So when we're looking at the contract of employment, it could be a written contract or it could be a verbal contract. A written or verbal contract should include details such as the type of employee that you are. So that's a permanent, part-time, permanent full-time or casual employee. Should include your rate of pay. So that could either be an hourly rate or a salary that you're paid across the entire year. It should include the leave entitlements that you are owed. So a contract may often refer back to the national employment standards and say that you're entitled to leave in accordance with the NES. And that means, again, 4 weeks for full-time employees for annual leave, 10 days for personal leave entitlements as well. Pro rata if you're a part-time, but no leave for casuals. The contract may also indicate whether or not you're entitled to any penalty rates, allowances, overtime work, and so forth. So it'll be a comprehensive document provided by your employer. If it's a verbal contract that you make with your employer, they are just as valid, although a little bit more difficult to enforce. What I would recommend is they still need to set out or contain the rate of pay, the type of employment, and the entitlements that you are owed regarding leave and allowances and so forth. If it's a verbal contract, though, send an email back to your employer with your understanding of what the verbal agreement is, so you've got something in writing to refer back to later in case there's any dispute about what you're owed. Now, modern awards, they is a industry-specific document that can also apply in addition to the national employment standards and a contract of employment. So there's a list of awards registered on the Fair Work Commission website. They're industry specific, so there could be the Retail Award or the Hospitality Award or the Building and Construction Award. So if you work in any of those industries, your employment's likely going to be covered by that award. So the award may set out greater entitlements for your rate of pay than just the minimum set out in the National Employment Standards. So if you work in any of those industries, have a look on the Fair Work Commission website and look at the entitlements that flow from that. So classifications based on the sorts of duties that you perform may entitle you to a higher rate of pay. If you're uncertain whether an award applies, the Fair Work Ombudsman has a Find My Award system where you can plug in the industry, your position title, and it can come back with a few suggested awards that may cover your employment. Again, if you're uncertain about any of this sort of stuff, ask your employer or come and seek legal advice. Now, an enterprise agreement is just like a modern award, but it also, but it only relates to a specific employer. So again, it'll set out the terms and conditions that apply to all the employees that are covered, that set out the rates of pay, the leave entitlements, any overtime, penalty rates, and other conditions of employment. The Fair Work Commission has to approve these enterprise agreements, and so they are all listed on the Fair Work Commission website, and there's a link there in the slides to find that. So if you don't fall within an industry-specific award, an enterprise agreement may apply, and you can search the Fair Work Commission website for your employer name, and those conditions will be set out there. Now, your employer must provide you with access to any of these documents. So if there's an applicable and modern award, it should be listed in your contract. Sometimes it's not, but you can ask your employer whether an award applies to your employment. Similarly, with an enterprise agreement, they have to provide you with a copy, or at least make one available at the workplace, so that you can look at it and you can request a copy be sent to you. But again, it's all registered and publicly accessible on the Fair Work Commission website. So make sure you have a bit of a search through those lists if you want to make sure. So some employees will have rights to extra pay depending on their terms and conditions and what documents apply to their employment. So the minimum wage has been set, so that's your baseline. Sometimes your employment contract will provide you with a salary or a wage that is higher than the minimums provided, and sometimes your award or enterprise agreement will also provide for higher rates of pay based on classifications and duties performed. So an employee may be entitled to overtime pay for hours worked in addition to your regular hours. So if you are a full-time employee, your maximum hours are meant to be 38. If you work 45 hours in a week, you may be entitled to overtime pay. If you work on evening shifts on the weekends or on public holidays, you may receive penalty rates, and you may receive allowances for uniforms, meal allowance, travel allowance. So again, all of these entitlements should be listed in your contract, award or enterprise agreement. There is a big caveat for these entitlements though, and these are offset provisions in your contract of employment. So if your contract of employment has an offset provision, what this says is that you may be receiving a higher rate of pay above that minimum award rate, minimum national wage. And if you are receiving a higher rate of pay, they can use the difference between the minimum and the higher rate of pay to offset any of these entitlements that you would normally be receiving. This has to be written specifically into your contract, so you have to be aware of it, and we have to make sure that you're not working 80 hours a week. The offset is not actually applicable because you need to still be compensated for the number of hours worked and work performed. So be really mindful that while the award and enterprise agreement may provide for some of these entitlements, if you are on a salary, there can be offset provisions where these entitlements are no longer payable. So payslips. Payslips are one of the biggest and most important tool you can use in monitoring whether or not you've been underpaid. Your employer must give you a payslip either on a weekly, fortnightly or monthly basis. Penalty rates must be evidenced on those payslips, and wages need to be paid during any trial period, so you should not be working for free at any stage. The Fair Work Ombudsman has a pay checker resource, and there's a QR code there to link you there. You can plug in the commencement date of your employment to your end date or any specific other time periods, and make sure that you are receiving the right rate of pay, the right accrued leave, any other entitlements. So you can compare what the Fair Work Ombudsman pay checker says against your pay slip. So again, it's really important to check your pay slips and make sure that your employer is giving you them. So by law, the employer has to give you a payslip every time you are paid. They need to be provided to you within 1 day of you being paid. They can be provided either in paper form, left at the office or your workplace, or they can be emailed to you digitally. I would recommend that if they are emailed to you, to have them sent to your personal email address, so that you can keep a record at home and make sure that it's a regular and up-to-date record of all the payslips that you receive. If you are sent payslips through an intranet process, or you need to log on through the employer website, or sort of a Xero program, download your payslip and save it, and send it to your own personal email address and save it at home so that you've got a personal record. If your employment ends, your access to those online websites may be limited and cut off, so you need to be able to access those payslips. Now, your payslip should show how many hours you've worked in a week, how much you were paid per hour, how much superannuation your employer has paid your superannuation fund, and how much tax has been taken out. So the superannuation and tax entries on your payslip directly refer back to that tax file number that you have to provide to your employer at the beginning of the employment relationship. So again, if you haven't provided those tax file numbers, they can't be paying you super and tax. So it's really important that those documents are provided. Fair Work Ombudsman has this fantastic resource available that tracks the number of hours you work. The thing that a payslip won't show is the actual hours, so the start time, the finish time, and the days that you work. Now, if you're an employee that is entitled to penalty rates or overtime or allowances for out of hours work or weekend work, you need to be able to keep a record of the actual start and finish times of each shift. Your payslip won't show that. It will just show the number of hours worked each week. So the Fair Work Ombudsman has an app that you can use on a daily basis. It's really important to log on to this and download it. It's a very handy resource, and it will track your hours for you. So when you start, you just plug in your hours. When you finish, you plug in those hours. And so if you need to pursue or count the hours that you've worked or calculate any underpayment, you'll have a very accurate record of the hours that you've worked. Again, so it's learning what entitlements that you are owed, depending on what sort of employment relationship you have. And then it's up to you to keep a record of your own hours so that you can enforce them if you need to. Cannot stress enough the importance of this app. Now, an employer can only make deductions from your pay in really limited circumstances. So if your employment has been terminated for any reason, your employer may claim that you owe them money for X, Y, or Z. Even during your employment, your employer may say that you owe them money and try and deduct money from your weekly pay. Now, an employer can only do this in really limited circumstances, and that's when they have the deduction written, authorised in writing from you. So they need to email you or send you a letter asking for you to approve the deduction, and the deduction must be for your benefit. So if you have been overpaid, or if you have damaged an item of property that you need to reimburse, those are for principally for your benefit, in that you need to pay the money back. But if they don't have that authorisation from you in writing, they cannot deduct that from you. So if you find that they are requiring money back from you, they can only do so once that authorisation is given in writing. The enterpriser agreement or a modern award may also provide for certain deductions. Again, your employer has to notify you of these deductions and only do them in accordance with the procedure set out in those two documents. So If your employer is trying to rely on the enterprise agreement or modern award, ask them to provide details of how they're authorised to do that. So, ensuring that you are being paid correctly, you need to look at your minimum rate of pay. At the very minimum, it's $20.33 if you're a full-time or part-time worker, according to the national minimum wage. The casual loading will be $25.41. They are your minimum bases. As I said, the contract of employment, award, or enterprise agreement may increase that minimum rate of pay. Make sure that you are checking and comparing your minimum rate of pay from your contract or award against your pay slip, and making sure that the hours that you've worked are being correctly paid in accordance with that rate of pay. If you are unsure about what your hourly rate of pay is and whether overtime, penalty rates, or any other allowances are due to you, you can talk to your boss about it and ask for clarification. I would be very wary about talking to your colleagues about rates of pay and discussing what your terms and conditions are. Sometimes in your employment contract, there are confidentiality directions where you are told not to discuss your salary or rate of pay with other people. So be careful speaking to colleagues. Go directly to your boss first for clarification. If you think that you have been underpaid in terms of number of hours worked or any other entitlements, there are a number of resources that you can have recourse to. So you can lodge a complaint to your employer first and say, these are the calculations that I've done for the underpayment that I think that's happened. Can you please rectify this? If the response is unsatisfactory, you can lodge a complaint to the Fair Work Ombudsman, contact Marrickville Legal Centre for some advice, or if there's a applicable union, you can speak to your union representative and see whether they can assist you. The cash in hand issue about payments for work performed is not illegal, but very risky. As I said before, the more documentation that you have in writing, the better it is, so that you can enforce your rights against the employer. You should still be receiving pay slips and being paid and paying tax on your cash in hand wages, but these sorts of arrangements really minimise the available sort of remedies that you can seek in enforcing any alleged underpayment. If you don't have any documentation or evidence as to what the agreement is for cash in hand, it's very hard to assert underpayments. So again, if there is a verbal agreement to be paid cash in hand, send an email back to your employer summarising what your agreement is, so that there's a record that you can rely on later. If you have been underpaid for any of the work performed, so the hours of work that you've worked each week, or overtime, or notice, it's unlawful for your employer not to pay you for that work performed. You can commence an underpayment claim in the Federal Circuit Court of Australia. You've got 6 years from the date you were underpaid to try and recover that underpayment. But again, it's important to keep those records and evidence to show how you've calculated the underpayment, just be it a weekly underpayment in regards to hours worked, or whether or not you've been paid any sort of entitlements such as annual leave or overtime. So keep those records up to date, keep your pay slips and timesheets current, and that will make calculating any sort of underpayment a much easier task. Ask your employer if you are an award covered employee or there's an enterprise agreement that covers the award. We've looked at the Fair Work Ombudsman Find My Award website link, or you can call the Fair Work Ombudsman for further advice. Keep notes, keep payslips, keep verbal, any sort of records of verbal agreements, and keep an up-to-date diary of the hours worked for your timesheets, or use the Fair Work Ombudsman Record Your Hours app. Details for the Fair Work Ombudsman are as follows. Let's see, yeah, they can help you find your correct rate of pay. They can look at whether or not your award covered or there's an enterprise agreement. They can look at whether your leave has accrued properly throughout the course of your employment, and that's including personal and annual leave, and any other allowances or overtime rates. We've got community legal centres, which is Marrickville Legal Centre being us, or if you don't fall within our catchment, you can find your local centre through the clcnewsouthwales.org app. There's the unions, in case there is a union representative or a union that would cover your employer, and legal aid can also provide some assistance. I'm going to open it up now to any questions that anyone may have in regards to underpayments. No.
Oh, I just realised Suki's muted. I'll just allow mic and camera. Joe, Justin, Suki, Sadi, I know you just joined us. We're at the tail end of the workshop at the moment, taking questions from the audience regarding the presentation on underpayments. So if anybody has any questions, feel free to unmute yourself.
I just have one question. I know that you've been talking about the standard award. I'm just wondering, is there any pay regulation for disabled workers, like, you know, how special employments who employs people with disability, do they actually have a pay schedule like us, or how do we know that if they are being paid? Is that according to some sort of award, or is that just according to the employment company? Yeah, just want to get understanding of how that works.
Yeah, do you mean disability workers or workers with a disability?
Workers with disability. So for instance, some of our mental health patients, they will go into supported employment, I think. Some of them work in a factory with sort of a minimum payment, but I think their minimum payment might be different to what you were talking about. So I was just wondering, yeah, I never know how that worked or how they were being paid. So I think for my clients or for the families and carers, I think, would you be able to explain, or do you know how that works?
Yeah, I think there's a supported workers award,
okay,
for workers requiring special assistance or coming through different pathways.
Yeah,
I'm not sure of. I don't know about any specific regulatory body. I think there may be, but I'd need to get back to you, and happy to sort of email you separately on this for specific legislation or regulations regarding the payment for the disability sector.
yeah, okay.
I think with just like with apprentices and other mainly apprentices, there are lower rates of pay under specific circumstances, and that will be set out in the employment agreement and arrangement. But I think there is an overarching body that will also regulate that I'll have to just double check for you and get back to you.
Okay, yeah, thank you.